Be ready for dictation. 5 seconds. Start. As the house belongs to appellant herein, namely Sri Fayyaz Abbas, he filed his objections under section 84 of the code, specifically pointing out that the appellant is the sole owner of the house by way of a will and that his son, namely Faiz Abbas, has got nothing to do with the house, and as the appellant is living in the house, consequently the attachment order be set aside. The Learned Court YD order impugned dated 12/7/2023 after considering the objections filed by the appellant indicating the aforesaid was of the view that while deciding the objections under the provisions of section 84 of the code, the court is not required to decide the dispute pertaining to a ownership of the house and that as the accused Faiz Abbas is only residing in 2 rooms of the entire house. Consequently, the order of attachment under section 83 of the code has correctly been passed and therefore the objections filed by the appellant have been rejected. Being aggrieved, the instant appeal has been filed. The argument of the learned counsel for the appellant is that the provision of section 83 of the code categorically provides that an attachment order can be passed for the property belonging to the proclaimed person who does not appear. Thus, the contention is that sine qua non to an order being passed under the provision of section 83 of the code is a finding may be prima facie to the effect that the property being attached belongs to the accused and without recording of such a finding in this regard, the property of a third person may be, in this case, belonging to the father of the accused, namely the appellant could not have been attached. He also contends that despite the objections in this regard being filed, the learned court has patently erred in law in affirming the order of attachment passed under the provisions of section 83 of the code solely on the ground that the accused is residing in 2 rooms of the entire house and as such it was within the power of the authority concerned. While issuing the order under section 83 of the code to have directed for attachment of the property, he thus contends that the order impugned merits to be set aside. On the other hand, learned AGA, on the basis of averments contained in the counter affidavit, argues that the FIR has been lodged in the year 2015 against the accused Faiz Abbas, the appellant herein and the wife of appellant, and thus there is no illegality and infirmity which has been committed by the competent court while passing the order under section 83 of the code in attaching the property of the accused, and further no perversity emerges from the order dated 12/7/2023 23, whereby the objections filed by the appellant against the order under section 83 of the code have been rejected. He thus contends that the instant appeal merits to be dismissed. Heard the learned counsel for the parties and perused the record. From a perusal of record, it emerges that admittedly an FIR had been lodged in the year 2015. Full stop over.